And my position is it's a farce to be in that situation before Judge Fritzsche. Here's a man on the bench that doesn't know when privilege attaches to a client. Here's a man on the bench that thinks a lawyer can prepare from scratch a felony defense overnight in direct conflict with the testimony of the court-appointed expert witness, Mary Davis, a career criminal defense lawyer. Here's a man on the bench that thinks because a huge conflict, Attorney Thomas Hallett's words repeated 3 times in his testimony in the subsequent page that you have before you, that because it wasn't on Van Dyke's radar, that conflict didn't need to be disclosed to the client. That Van Dyke, was pressuring to plead guilty a second time. The first guilty plea was vacated when Doyle presented evidence that Steve Diamond, a Stanford law grad, had lied in his proffered testimony in the pretrial discovery, while holding the position as legal counsel for the Securities Regulation Bureau. Here's a man on the bench that thinks that Peter Detroy, whose firm and he personally made millions of dollars on the car test and cigarette cases from the state, should testify against one of his clients as a favor to the state, when in fact Detroit's entire knowledge of the case came from privileged information. And finally, here's a man on the bench that when a freedom of access was filed with Mary Lynch, the court's freedom of access officer, could not produce a single case where Fritzsche had ever granted a trial from a post-conviction review hearing. A statistical deviation of monumental improbability if there was anything approaching legal conduct under the law. What we have here is another renegade judge like Martin that was questioned by this committee on his illegal, nonsensical interpretation of Rule 76H and defied the committee at his renomination hearing while this committee quoted the rule to him in this very chamber. Fritzsche should not be given any more time on the bench to abuse other litigants whose only desire is to have a fair trial devoid of behind-the-scenes scheming and crooked dealings. This committee needs to protect the citizens of Maine from Fritzsche and from all future harm he can do. I'd like to direct you to the next page, at the bottom of the page, where a discussion takes place about where privilege attaches. And it's very clear from Mary Davis in questioning back and forth of whether attorney-client privilege attaches with or without a fee. And Judge Fritzsche wrote in his decision, no attorney-client privilege existed between Mr. Doyle and Mr. Detroit. And Mr. Detroit's entire knowledge of the case came from meetings with Mike Doyle and the advice I sought from him. It's unbelievable, incredible that the ruling would be like that. On the next page, Hallett actually testifies 3 times, starting at page 59, about a few lines down from the top of the page, that this would have been a huge thing, a huge thing, a huge thing, had Van Dyke disclosed that he was being defended by Peter Detroy, the chief witness against me, who got his information from privileged contact. Hallett says, I think that prohibits that kind of conflict in 3.4, he said it at one point. Then Peter Detroy, Hallett's discussion of Peter Detroy having to be questioned by his own client, who he was defending for malpractice, David Van Dyke, he said it was going to be ugly, nasty, ugly. 3 different comments about having to question your own defense lawyer on the witness stand. And then Mary Davis makes the comments that Van Dyke was aware of the conflict and he didn't notify Mr. Doe because he thinks it will make no difference. Right, is that the way it's supposed to work? And her answer was, that affects, if he knew and didn't notify his client, that does make the effect that is required for ineffective assistance. It just has to affect the representation so that it would be serious. Clearly a deficiency. It would affect the representation, underline. Lack of conversation. Going on to the next page, Judge Fritzsche has this discussion. I was aware that there were numerous opportunities for Mr. Van Dyke to make the disclosure. He failed to make those disclosures. Then he goes down and actually in his order, after making comments about swagger and bravado, in his order he says there's no credible evidence that there was any problem between Mr. Van Dyke not notifying me that he was being represented for malpractice by a lawyer that was going to testify against me. Starting at page 36, he talks about swagger, bravado, and machismo in his conversation with the witness, Mary Davis, on the witness stand. And then you go down further, he actually puts it in his order that Van Dyke had enough swagger and bravado to prepare a felony trial overnight with zero preparation, no list of witnesses, no filings of motions, nothing. This is just an incredible misconduct of a judge sitting on the bench. And it goes on to a point where I got a letter from Peter Detroy's office, a copy of which everyone in the chain of the letter denied any knowledge of it. Everything was denied. The letterhead was the wrong letterhead. It was the wrong way of writing it. One thing that was never denied by Cab Howard was that it was Peter Detroy's signature on the letter. Thank you for your time. Any questions?
Thank you very much, Mr. Doyle. Do you have any questions, Mr. Doyle? Seeing none, thank you very much, sir.
Thank you.